My name is Noam Lubell. I'm a professor in the School of Law and Human Rights Center at the University of Essex and director of the Essex Armed Conflict and Crisis Hub. And this is a speaker series that is organized by the Human Rights Center and the Conflict Hub. And as you know, we are focusing on the war in Ukraine and the protection of civilians, with particular reference to the international legal aspect of it, but not only, as you're going to see. So just a few background words, and then I'll introduce our panel and explain how this is all going to work. We are going to have relatively short presentations by the panelists, and we're hoping to leave plenty of time for discussion. I'm sure there's going to be lots of questions. The questions can be asked in the Q&A, and if you place your questions there, I will read them out. If there are too many questions, I might have to sort of combine questions, but I will read them out and pass them on to the panelists. And also, if you don't want your name to be read out with the question, then please say so, or there might be I think there's an option to post your question anonymously. So today, as we mentioned, we're going to focus primarily on aspects related to protection of civilians. Now, before we address that, I just want to say one short word about why we're looking at this. It might seem obvious, but I've also heard sometimes there are some comments on sort of, this isn't the only war happening. There are other things going on, as terrible as it is. And it's true, this is not certainly not the first war in violation of international law, not in recent times even. It's not the first time in recent years that the whole country has seen its cities devastated, including with Russian involvement, by the way, if you think of the Syrian conflict. The suffering and harm caused in other conflicts is no less devastating. This is also the case with regard to refugees. I'm going to be talking about refugees as well. For example, even the discussion here in the UK about opening up homes to Ukrainian refugees, while at the same time thousands of Afghan refugees are still stuck in special hotels without finding a home. So all of that is true. But whatever one makes of comparisons with other conflicts, none of that takes away from the reality of the terrible events in Ukraine that are unfolding before our eyes. And we're here to talk about that today, about the fact that Ukraine has been invaded, its cities are being shelled, civilians are being killed, millions of people have been displaced, and the response of the rest of the world is under scrutiny. And notably, given what appear to be blatant violations of fundamental principles of international law, questions are being asked also about the credibility of the international legal system. So the panel we have today is made up of people with significant expertise across a wide range of areas in relation to protection of civilians in times of conflict. And they're each going to give a brief presentation, after which we're going to have plenty of time for Q&A, as I mentioned. I'm going to introduce them all together at the start, and then we'll get going. So we have Carla Firstman, who is a professor in the School of Law at Essex. Carla is also a barrister and solicitor. She's a member of the Council of Europe's Expert Council on NGO Law. She's a judge on the Hybrid Tribunal, which is an international people's tribunal to investigate atrocities alleged to have taken place in Iran in the November 2019 protests. Carla is also on the Advisory Committee of Lawyers for Justice in Libya. Years ago, she worked for the UN High Commissioner for Human Rights in Rwanda. She's also worked in Sarajevo, where she was the executive legal advisor of the Commission for Real Property Claims of Refugees and Displaced Persons. And importantly, Carla, from 2004 to 2018, before joining Essex, was the director of Redress, a leading NGO I'm sure you're all familiar with that works on protection from torture and related international crimes. After Carla, we're going to turn to Annie Schiel. Annie is a senior advisor US at the Center for Civilians in Conflict, also known as CIVIC. Civic, if you don't know them, I urge you to check out their website. They really have become one of the more important organizations in recent years working on protection of civilians in conflict globally. Annie leads Civic's work engaging with US policymakers, lawmakers. That includes leading Civic's policy analysis and advocacy around civilian harm implications of US military operations, working with others to try and change policies around this that improve the lives of civilians in conflict. Before joining Civic, Annie was a research program manager at Stanford University, where she led research on civilian harm and humanitarian response. And she's also spent 3 years working in the US State Department on issues of human rights, civilian protection, and security sector reform. So Annie brings a lot of policy expertise and will be able to talk to us about some of the practical aspects of what happens during a conflict to try and improve protection of civilians. After that, we'll turn to Jeff Gilbert, also a professor of law in the School of Law and Human Rights Center. Jeff, a couple of years ago now, was appointed as the inaugural chair of the Global Academic Interdisciplinary Network that was launched at the first Global Refugee Forum. And this is part of the Global Compact on Refugees. Jeff has extensive experience of over 25 years working with UNHCR on a wide range of important research projects and training programs relating to protection of refugees and displaced persons. He's been specialist advisor to the Joint Parliamentary Committee on Human Rights in its inquiry into the treatment of asylum seekers back in 2006 and 7. He's done reports for the Parliamentary Assembly of the Council in Europe, dealing with minority rights. And Jeff has also carried out human rights training on behalf of the Council of Europe and UNHCR in the Russian Federation, in Georgia, Bosnia-Herzegovina, Croatia, Macedonia, Kosovo. So he knows the area. He's advised governments in Central and Eastern Europe and beyond. One more speaker that's not with us right now, but will be joining later. Unfortunately, schedule issues that were unavoidable, but we still are going to be happy when she joins, and that's Natasha Lindstadt. Natasha will, when she joins, be giving a view from a different perspective. Natasha is a professor in the Department of Government here at Essex, and she is an expert on authoritarian regimes, populism, failed states. She's written books on authoritarianism, on democratic backsliding, on authoritarian populism. And Natasha is going to be able to give us some really important insights into not just on the Ukraine side, but also Russia and what's happening in Russia. And people are talking about these aspects from the politics and international relations of all of this. So when Natasha joins, we'll turn to her for some thoughts. So we'll get started now with Carla. Each of the presentations will be around 10 minutes, a little more, and then we'll open up for questions after we finished all the presentations. Carla, over to you.
Thank you so much, Noam, and it's a great pleasure for me to be part of this panel. It's such an important topic, and I think the picture is moving so fast and so quickly that the more reflection that we can have, that we can do, the better. So I'm going to make a few comments about the legal, basically the legal situation with respect to the crime of aggression and the different debates that are beginning to emerge about what are the possibilities for justice, both in terms of what crimes, what potential crimes, also what forums. But the first thing to say is perhaps most important is that this is a moving picture. There's a lot that we know because of all the videos and other information that is circulating, but there's probably also much that we don't yet know. It's an ongoing conflict which has its own path and its own complexity, and it's definitely not over, and there's definitely more to come. As usual, ordinary people are suffering the most. What does international law say about what is happening? And what can international law do about what is happening? You'll see that it's really not very straightforward. Accountability is almost like trying to fit the square peg into the small whole. So firstly, turning to the crime of aggression. Aggression is clearly illegal. It violates Article 2, Paragraph 4 of the UN Charter, which deals with sovereignty and non-interference in the affairs of another state. What are the legal avenues to adjudicate aggression? Can Russia be brought to court for waging war? Not a clear answer here. Russia as a state, one needs to consider what venue would be available to bring a claim and to have a claim against Russia, a state, for the crime of aggression. The International Court of Justice, which is the obvious state-to-state claim, doesn't have automatic jurisdiction. A narrow case that has been brought by Ukraine before the International Court of Justice deals with a much more limited question about whether Russia's arguments about why it began its incursion were appropriate. So essentially, it turns on the definition of the implementation of the Genocide Convention. Ukraine is arguing that Russia's premise for entering the war is flawed, and on that basis, it should be told to stop. The court will focus on that. But separate from state responsibility for aggression, there is, of course, the possibility that individuals may be held individually criminally responsible for waging aggressive war. So where could this possibly happen? The obvious first place that we might think about is the International Criminal Court, which in essence has been set up to deal with the most egregious crimes known to humankind. Aggression, however, was agreed in a different way than the other crimes were agreed to before the International Court: war crimes, crimes against humanity, and genocide. Aggression applies to senior leaders who wage war, but more importantly, the court would only be able to act on aggression if both Russia and Ukraine were state parties. And in fact, neither of them are. Even if both states were to become states parties today or tomorrow, which is obviously a difficult and very unlikely prospect, their ratifications would not have retroactive effect. And both Russia and Ukraine would have to agree to the ICC's specific framework on the crime of aggression. So this is clearly something which is dubious and unlikely to happen, certainly in the short term. And the absence of retroactive effect makes the possibility of the International Court engaging on the crime of aggression virtually nil. Domestically, a trial, one could imagine, could take place by Ukraine or by a group of countries who come together to look at these different types of crimes. The crime of aggression. And in future, by Russia or Belarus, if that might indeed ever be something that could even be imagined. This could happen, but the main issues here are immunities of acting head of state and senior leaders and getting custody over those persons. It could really only happen after a change in leadership. Another possibility, which is being mooted, is another form of international criminal tribunal, which deals specifically with the crime of aggression. Normally, it would be for the UN Security Council to create such a tribunal on the basis that the UN Security Council has an overall mandate to deal with matters involving international peace and security. But clearly, given that Russia is a permanent member of the UN Security Council and has veto power, it would be very difficult for anything regarding Ukraine to proceed before the UN Security Council, difficult, nigh impossible. The UN General Assembly could potentially cooperate with Ukraine to create some other kind of hybrid tribunal. And this has been suggested by some international lawyers as the best way forward. But still, there may be immunities problems here too. And also the General Assembly doesn't have the obvious mandate that the UN Security Council does with respect to international peace and security. Also, there's the issue of selectivity and prioritization. Why is there consideration of an international tribunal for crimes related to Ukraine and not for other acts of aggression? Next question we can ask, what does international law say about the other kinds of horrific crimes that we are beginning to witness? So there's been reports of all kinds of acts like targeting of civilians in Ukraine that would likely amount to war crimes and potentially also to crimes against humanity. How can these acts be prosecuted differently from aggression? So here the International Criminal Court is a much more obvious fit. Ukraine is not a state party, nor is Russia, as I already indicated. However, Ukraine has formally given made a submission to the ICC. It's specifically given the ICC authority to become involved. And additionally, 41 member states, which is landmark, have requested the ICC to become involved in this matter. The ICC prosecutor has already indicated that an investigation is underway. So this seems quite likely to be something that will happen. The challenges here are twofold. Firstly, there's a lot of political pressure on the Office of the Prosecutor to go forward. It's really important for the Office of the Prosecutor to focus on evidence, to focus on the law, and to keep it all in the sphere of legal investigation, and to try where possible to resist the intense pressure to proceed with this investigation ahead of perhaps the many other files which are already open. Other countries or another international criminal tribunal could easily be established with respect to war crimes or crimes against humanity. But here, the debate would be on why should we have a special tribunal for Ukraine when the International Criminal Court is there, is ready, and is already investigating. One might note that the International Criminal Court already has, the Office of the Prosecutor is already engaged with respect to Ukraine in relation to 2014 Crimea issues. Another issue that I'd like to mention quickly with respect to legal issues and possible prosecutions or legal processes is the issue of arbitrary detention and torture of protesters in Russia and Belarus. Here, it's important to note that Russia has given notice of its intention to withdraw from the European the Council of Europe, and in consequence, the European Convention on Human Rights. Belarus is not part of the Council of Europe anyhow. In principle, until Russia formally withdraws, the European Court of Human Rights remains competent and judgments would be binding on Russia. But the problem is that Russia is unlikely to implement the judgments or to pay any attention to them. Under the Torture Convention and the International Covenant on Civil and Political Rights, both ratified by Russia and by Belarus, torture and arbitrary detention are crimes. They should be capable of being prosecuted domestically in theory, but also for torture if an alleged torturer is found in another country, then there is an obligation for that country to either prosecute or extradite that individual. So the possibility of torture prosecutions in relation to what we know about how protesters have been treated in Russia and to an extent in Belarus as well is something also to watch for. A final comment, just to conclude on the issue of reparations. How does one account for all the harm, the loss of property, livelihoods, and the injuries to civilians from a legal perspective? So usually after an international armed conflict, the issue of reparations would be agreed either as part of a settlement or potentially as part of a court order following a legal judgment, for instance, before the International Court of Justice, as has recently happened in the case of Congo against Uganda. Another possibility might be an arbitration proceeding, as has happened in the matter between Ethiopia and Eritrea Claims Commission. But this is likely to take a very long time. The Congo matter took upwards of 20 years before a reparation order was even identified. So here it's important to note that law is important, but it's important that we don't wait for the law to work when the victims, the families, the communities are going to need urgent support to deal with the humanitarian situation that they face. So perhaps I'll stop there, but thank you, Noam.
Thank you very much, Carla, for that informative presentation. Hopefully those that weren't familiar now will have a better understanding of some of the legal responses and what's starting to take place, and what will come into some more of those points later on. But for now, let's turn to Annie to hear more about the policy side of things and what actually can be done on the ground and from the outside and from other states, including over the Atlantic, to try and improve the protection of civilians. Annie, floor's yours.
Yeah, thank you so much again for having me. Really happy to be here. So as you noted, I work for Center for Civilians in Conflict, or CIVIC, which is an international organization dedicated to the protection of civilians in conflicts around the world. By way of a bit of background, we have programs in Iraq, Yemen, Nigeria, in the Sahel, in East Africa. We have a program that works with peacekeeping missions. And then, of course, we have a program in Ukraine. And as mentioned, I actually lead our US program, which means I lead our advocacy with the US government, focused both on civilian harm that arises from US operations themselves, and then also looking at the civilian harm risks of security assistance activities, including arms sales and arms transfers. CIVIC's work, of course, looks a little bit different in every conflict where we work, but predominantly our work consists of two main things. One is working with armed actors to increase their will and their capacity to prevent and respond to civilian harm. And the second is working directly with communities of civilians that are affected by conflict to support them in their quest for protection. Our team that's in Ukraine has been there since 2017. They've been conducting research. They've been working with the Ukrainian government to develop and implement protection of civilians policies. And they've been working to strengthen dialogue between the Ukrainian military and civilians in the east of Ukraine to allow civilians to make their protection needs known. Of course, all of that work has changed in the last few weeks. Our team is still on the ground, and they're working very hard to track and analyze trends in civilian harm after the Russian invasion. They are obviously the experts here, but given how busy they are, I'm going to do my very best to represent their work today and hopefully to complement Carla's very comprehensive legal analysis with some of the facts that we are seeing on the ground. So on March 9th, our team put out our interim findings on civilian harm in Ukraine, informed by our team's local networks and our work with civil society and communities. And I'll put that in the chat when I'm done. But I'll just kind of lay out briefly those findings. The main finding that we found was, unfortunately, that civilians have become a prime target of the Russian armed forces following their invasion. So in the earliest days of the attack, initial reports focused on significant civilian harm, civilian casualties resulting from fighting in densely populated areas and from the use of explosive weapons in cities. But as the conflict has escalated, reports of attacks by Russian forces have really appeared to be directed at civilian areas, including, of course, apparent violations of international humanitarian law. And some sources have attributed that change to changing Russian tactics, right? That as their initial assault seems to fail, Russian forces reportedly switched to shelling civilian areas to break resistance. We have also seen threats to civilians come from attacks on critical infrastructure and on dangerous sites. So that includes things like strikes on hospitals, on schools, on orphanages, as well as sites like oil depots and other energy-related installations. And of course, we also know that civilians are being denied safe passage out of conflict zones. We've seen civilians be shot at by Russian forces and used as human shields. So I think it's important, that we recognize that while we've already seen millions of Ukrainian refugees fleeing the country, as well as millions of internally displaced people, we're also seeing so many civilians currently living under siege, right, who are trapped in war and unable to access essential services, food, water, fuel. And lastly, I'll note that we are also seeing reports of cluster munitions and other unexploded ordnances littering populated areas throughout Ukraine, which of course will come with long-term consequences for civilians, as we've seen with unexploded ordnance in other parts of the world. So in terms of our advocacy and our key asks, we are of course asking for an immediate ceasefire to allow for safe evacuation from areas that are under constant fighting and to permit the delivery of humanitarian assistance into those areas. Of course, calling for Russia to stop targeting civilians and civilian objects, which is a challenging ask, right? If there is not the will to make that change. Asking for the negotiation of evacuation routes to allow civilians to safely leave conflict-affected areas in ways that guarantee their safety and also their dignity and their protection. Asking for safe humanitarian access routes to get humanitarian aid into these besieged cities. And then, of course, as Carla mentioned, we also continue to ask for support for accountability processes, like the operationalization, of the newly created Independent International Commission of Inquiry on Ukraine. And then for international allies of the Ukraine, which of course include the US, as they work to deliver lethal and non-lethal equipment to Ukraine, they should also really be focusing on supplies that are crucial to civilian protection, including things like protective vests and medical equipment, and for those things to be distributed to civilians where possible. That was a very brief rundown, but I think I'm going to stop there to leave more time for the discussion. But again, thank you so much for having me, and I'm really looking forward to digging in more during this conversation.
Thank you very much, Annie. We'll turn now to Jeff for his thoughts and analysis regarding refugees and displaced persons.
So, thank you for inviting me to this presentation. It's amazingly important that we discuss this. But I do want to set it in context to start everything off. So, according to UNHCR's website this morning, there were 3 million refugees who had fled Ukraine. 1.8 million had gone into Poland. Everybody else has gone into other neighbouring countries, most of which are European Union member states, Moldova and Russia being the exception. Some people have fled into Russia. There's 2 million internally displaced persons within Ukraine. But you need to also be aware that according to the humanitarian response plan for 2022, which came out in December this year, there were already 2.9 million people in need of assistance prior to the conflict. To give some sort of setting for this, there are currently 6.7 million Syrian refugees, and Turkey hosts 3.7 million of them. And there's 6.6 million internally displaced persons in Syria. There's actually 137,000 refugees in Yemen, mainly from the Horn of Africa. And there's 4 million internally displaced persons in Yemen. There's 82.4 million persons of concern to UNHCR worldwide, and 86% of them are in low or middle income countries. It's not that I'm trying to say, oh yes, Poland is nothing, sorry, Ukraine is nothing, and Poland's reception of 1.8 million isn't incredibly generous. But it helps to have a perspective on just how much Ukraine adds to an enormous refugee displacement problem that the world was facing, and which to a certain extent got lost when the COVID pandemic started. It was sort of headline news in 2019, and then COVID came along, and somehow it got pushed onto the back burner until Ukraine comes along. And it's really important that the protection that is being offered to Ukrainians in neighboring states continues and is made available to refugees from any conflict zone or situation of persecution. Article 3 of the 1951 Convention relating to the status of refugees says that all contracting states shall apply the provisions of this convention to refugees without discrimination as to race, religion, or country of origin. And I think this is really important. We are seeing incredible generosity towards Ukrainian refugees. Let's remember that there are lots of other refugees around the world, and that same generosity can be shown to them. What though about the situation, particularly in Ukraine? So, as I've said, most refugees, like in every other situation, have crossed a single border and they're in one of the neighboring states. All of those states, bar Russia and Moldova, are member states of the European Union. And this has given rise to one particular aspect of protection of those fleeing Ukraine that we haven't seen. The European Union has triggered the Temporary Protection Directive, and this means that within the European Union, persons fleeing Ukraine are being distributed amongst other member states of the European Union than those that just neighbour Ukraine, so that they are being transferred into states further away in the European Union, states not on the border of Ukraine. If I were the Greek government, I might be asking why this has been triggered for Ukraine, not Syria, but that's a separate issue. What we are seeing, though, is Dublin, the Dublin Agreement. It's actually now a regulation that normally allows European Union member states to return persons seeking asylum, refugee status, to the first member state in the European Union where they entered. That is being suspended for Ukrainians. Ukrainians can go into Poland and will then be, hopefully, distributed in a fair fashion across the whole of the European Union. And when we say fair fashion, we should remember, of course, that countries like Italy are already receiving lots of refugees from Libya. So this fair distribution has to take into account, or should take into account, the current refugee hosting populations in all the member states of the European Union when distributing Ukrainians who have fled into neighbouring states around the rest of the European Union. It's possibly one of the worst aspects, to my mind, of what we've seen in the UK since Brexit, how the United Kingdom government has responded to the Ukrainian crisis. The UK government is continuing to treat those fleeing Ukraine like any other person seeking to immigrate into the UK and is requiring visas. This is contrary to every aspect of how one should deal with protection crises. I'm not saying that the UK government can't do this. It is perfectly entitled under law to require visas of those coming from Ukraine. But it does seem totally ridiculous that this is being applied in such a large-scale crisis, that somehow or other we need a visa process. There are many ways the UK government could have responded in a much more generous fashion. It could have worked with UNHCR who will have registered and documented everybody coming out of Ukraine, and then taken people directly, flying them to the UK. It would have been possible to do that without making them go through some ridiculous visa process that is still being imposed. It makes no sense to me that we are confusing immigration control with protection of people fleeing conflict and persecution. And that is something that at some point needs to be raised, but that's for politicians in the House of Commons, House of Lords, and doesn't really come as a major issue for us today. I want then to move on to one further aspect of the conflict, which Annie has alluded to already, the humanitarian corridors, these safe corridors, safe zones that we've seen. Now, safe zones and safe corridors are not new. They've been around for decades. As a consequence of the Syrian crisis, Russia, Iran, and Turkey tried to set up safe zones in parts of Syria for the return of Syrian refugees. Turkey has already designated some areas as safe. Whether it has pushed back, refooled people there is not 100% clear, but it's definitely set them up as though these are places to which you could return people who are seeking asylum, seeking refugee status. Safe corridors. This is a confusing term because it's not defined, and there are different types of safe corridor. One that is classic is where you have a conflict zone and you establish safe corridors so that people in remote areas can get to hospitals. Hospitals tend to be built in large population centres. You don't get them everywhere throughout a country. So if you take a conflict like the one in the Democratic Republic of Congo, safe corridors to places where there are hospitals is a very different concept from safe corridors out of Ukraine that we're currently talking about. So the safe corridor idea has to be understood as one where you have to define what you mean by safe corridor. In this particular context, we're talking about safe corridors out of Ukraine and into neighboring countries in a way that means that people using the safe corridor are not at risk. Now, I'm not going to go into any great detail on the international law of armed conflict. We have Noam here. But two of the most important principles of the law of armed conflict are the principle of distinction and the principle of proportionality. And the principle of distinction, as has already been mentioned, means that civilians should never be targeted. And principle of proportionality means you only use those weapons that you actually need to be able to use to attack military objectives. You don't use weapons that might kill a disproportionate number of civilians caught up when a military objective is being targeted. If that's the normal law of armed conflict, that civilians should never be targeted, then a safe corridor, a humanitarian corridor out of an area which is being attacked, must offer more than just the basic international law of armed conflict protection. Safe corridors must be such that there is no possibility even of collateral damage in the safe corridor. As long as it is being used for humanitarian purposes, then that should be a safe way to get out without any risk. Otherwise, it's no better than just being caught up in and using the ordinary laws of armed conflict where civilians don't target us. As Annie has also mentioned, humanitarian access. Under international humanitarian law and under Principle 25 of the Guiding Principles on Internal Displacement, parties to the conflict, those who are dealing with internally displaced persons in whatever fashion, should respect the humanitarian access to deliver humanitarian supplies, food, medicines, so that those caught up, those internally displaced, can be protected by those humanitarian workers who follow the humanitarian principles of independence, impartiality, neutrality, and humanity. What we are seeing in Ukraine at the moment, which is mirrored in conflicts throughout the world, is a lack of respect for those seeking protection. We need to have mechanisms by which that can be put before somebody that can enforce it. And as Carla's very complete explanation showed, that's more difficult than it sounds. On that note, I'll pass over to Noam.
Thank you very much, Jeff, for that excellent presentation. Before we open for discussion, and as mentioned, we will have Professor Natasha Lindstadt joining us soon as well. But before we open up, I just want to say maybe a few words about the international humanitarian law perspective of some of the actual military operations, because there are a number of things going on, some of which appear to be straightforward, clear violations, and some of them might be a little bit more complicated than they seem, and some are raising real questions about how international humanitarian law works. So as Jeff just mentioned, the principle of distinction is a fundamental. In some ways, it is probably one of the most important principles of IHL. A lot of the rules can be traced back to this basic idea of distinguishing between military and civilian, attacking things that are military, and doing everything possible to ensure that civilians and civilian things are not harmed, and certainly not ever deliberately attacking them. And what we're seeing here appears to be straightforward a violation of that, because we're seeing shelling of wide urban areas that appear to have no military installations. And so a lot of questions are already being asked about this. Annie mentioned the use of cluster munitions. Cluster munitions, in terms of their legality, there is a convention prohibiting their use, but not everyone is party to them, and Russia isn't. In this case, neither is Ukraine, I believe. So then the use of cluster munitions, it doesn't mean that it's necessarily lawful, but you have to turn to the general rules of humanitarian law. And here we come to the question of, even if in theory, and again, not everyone agrees that they're lawful, but even if in theory they are lawful, using them in an urban environment is highly problematic. Generally speaking, using any explosive weapons that have a wide impact in an urban environment is likely to be indiscriminate. Again, and this is part of the problem where, and I am on purpose being careful when I say likely to be indiscriminate, because one of the difficulties from the legal perspective is to sort of outright immediately you see something and to make a determination of legality. Now, sometimes you can, sometimes it's straightforward, but on issues relating to targeting, and this is why a lot of what we're talking about now is we're calling for investigations, and even if you talk about the ICC, they start with investigations, is because from a targeting perspective, proving the war crime can sometimes be a bit more difficult than it seems, especially when you don't have cooperation from the accused party. Right. So in cases of targeting, for example, you need to know what they were attempting to target, what precautions they were taking, and what they could have anticipated in terms of the effect. You also have got the challenge of gathering evidence. You need access to the area, which can be extremely difficult, at least at the moment that things are happening. So as I say, from a lot of what we're seeing, it seems fairly clear that the violations are taking place and potentially war crimes, but one needs to substantiate them with the evidence, which I assume will be happening. Also remember, we're not just talking about casualties in terms of civilians, but also civilian objects, the buildings themselves, but also damage to infrastructure, longer term effects, and all of this can be part of what could end up being violations. There are also objects with special protections that appear to, again, they're being hit, and one needs to establish whether this is intentional or not. One needs to also see, even if it's not intentional, could it have been expected and potentially disproportionate? A pattern sometimes can help establish this. So even if you don't have cooperation, for example, in your investigation with the other side, if you see something happening again and again and again, sometimes that can be enough to establish intentionality. It depends. One of the bigger concerns that we're seeing in this conflict is one that comes up generally in conflicts when we have what's sometimes called urban warfare. Right? So when we think about sort of armed conflict, and historically, at least some of the laws of armed conflict started out thinking of a conflict that's clearly taking place between two armies, and hopefully armies on a battlefield. Right, and in those situations, it's easier to say, you target only the military objectives. Equally, by the way, the defender has obligations, and the defender is expected to refrain from operating within civilians and to refrain from locating its own military objects within civilian objects. And urban warfare has always presented a challenge to this. Now, it gets particularly complicated when, as we have now in Ukraine, when it appears that there's no choice for one of the parties. Right. So if one side is directly attacking the cities, it starts off the conflict, attacking cities, they're trying to capture and control cities, then the other party will by default be defending from within the urban area. Right. And this sounds fairly straightforward. But then you have to remember that when you're defending from within an urban area, you are quite possibly going to end up, and this is from from a military doctrine, is what urban warfare is, you end up using civilian objects to hide, right? You're hiding in buildings, behind buildings, you're launching attacks. Why? Because you don't have it. It's not an area where you're sort of operating from within military bases. Looking at other conflicts, we're quick to criticize armed groups for fighting from within cities and so on. It's interesting to see the reactions here when it's a state acting in self-defense and operating from within cities, because it creates a bit of a vicious cycle. Right? So if you think about it, the Ukrainian side has its armed forces or volunteers, and we can come to that in the Q&A in terms of all the civilians taking up arms and so on, operating from within urban areas. Now, from an IHL perspective, if they are using force and targeting the Russians from within there, then they could be legitimate targets. Potentially even some of the objects that they're using to operate from could be. which then suddenly from an IHL perspective can allow for more harm to happen inside the cities, right? In line with proportionality and so on. And certainly there are limits, but it complicates things. And there isn't a straightforward answer here. Some of this is down to the distinction that is made between what we call the jus ad bellum, so the resort to force, who is the aggressor, who is the victim of force, and IHL, the jus in bello, the laws that apply during the conflict, because the latter applies equally to both sides. Both sides can target military, right? And so, you might, when you see situations like this, say, well, the Russians shouldn't be allowed to target anything. But that's not how IHL works. Once you're in a conflict, both parties have things they can target and things they can't. And so, as I say, this what's happening now with fighting around the cities makes things a little bit more complicated in that sense. So there's a lot going on from an IHL perspective that we can also talk about. I mentioned also some civilian participation. There are questions around sieges. There's questions around how you classify some of what's going on here, what happens if other states get involved. But I didn't want to be making a long presentation myself, so I'll open up now for the Q&A, and maybe the other panelists can rejoin with their cameras, and we'll start taking some questions. As I mentioned, Natasha Lindstadt will be joining at some point, and when she does, we'll take a break from the questions to hear from her. So maybe I'll start, Carla, with a question for you from Ahmed Suleiman, who's asking about the credibility of the international legal system in the context of Russia being a permanent member of the Security Council and having the veto power, and whether this means that potentially we need to be turning more to the General Assembly of the UN rather than Security Council to try and get some responses from the UN.
Difficult question. I think the credibility of the international system as a whole is obviously shown when the major international organ in charge of international peace and security is virtually blocked. It won't be the first time, however, but certainly it says something very fundamental about the international legal order as a whole. With respect to the General Assembly becoming more powerful, and potentially, yes. However, one needs to recognize the limitations of mandate. So it's not as if the General Assembly can simply start acting like the UN Security Council. So I think there's limits. I don't think it's a very clear-cut way forward. Certainly, a lot of what will ultimately happen will depend on what states wish to recognize in terms of what will happen. But I think it would be problematic for the General Assembly to simply step up with and pretend that it's a Security Council. That rebalancing without greater care, let's say, could have wider repercussions, which wouldn't necessarily be helpful in the long term.
Great, thanks, Carla. Jeff, you want to come in on this?
Yeah, just something that goes back to the 1990s when the Security Council set up the International Criminal Tribunal for the former Yugoslavia and the International Criminal Tribunal for Rwanda. One of the questions that was raised then, and I'm not a General Assembly powers expert, was why was the Security Council setting up a court when that was ordinarily seen as something that the General Assembly did? So could the General Assembly now set up a court to prosecute? It wouldn't have the Chapter 7 authority that the ICTY and ICTR had, but could it set up a court to prosecute after the event? It's just something that was raised during the Tadic way back when.
I don't know if that's a question back to me, but I would say I think it's possible, and there's probably even some precedent in terms of UN organs not necessarily setting up, but endorsing certain internationalized or hybrid courts that have been set up. So the extraordinary chambers in the courts in Cambodia, the special court for Sierra Leone, where what's important about those courts is that you had state consent. And I think that would be the difference. And that, of course, is something which could happen with Ukraine, clearly. So then the issue becomes, to what extent does the law on immunities, how will that impact a court which has not been set up under Chapter 7? And how will one get hold of the suspects?
Great, thank you for those answers. I think we'll take a quick break from the Q&A and go back to the presentations. So as mentioned earlier, Professor Natasha Lindstadt wasn't able to join us right at the start, but she's here now. Natasha had already given a brief bio of everyone, so I won't go into a long introduction, but just to remind everyone that Natasha is an expert on authoritarian regimes in particular, and we've been looking at sort of policy perspectives and legal perspectives, but to hear something more from the view of someone with a background in international relations and politics will, I think, be extremely important here as well. So Natasha, over to you for a few minutes, and then to everyone, we'll come back to the Q&A after that.
Thanks, Noam. I was going to just ask to what extent you had already discussed the sanctions that have been applied, or you were speaking it from, okay. I just want to make sure I'm not repeating. I'm going to try to keep it short to a couple of things that might be notable. Sanctions weren't used very often before the 1990s, before the end of the Cold War, and really rarely used. So when I'm talking about studies that have looked at things, we don't have loads and loads and loads of cases to look at. The sanctions being applied to Russia right now are by far the most comprehensive on such a big country that's so integrated into the international economy. So in some ways, it's a critical case. We haven't really seen anything like this before, and that's been the main tool that's been used on Russia. And you have different goals with sanctions. You're either trying to promote democracy and human rights, or you're trying to engage in some kind of nuclear non-proliferation or conflict resolution. And the studies that have been done in terms of are sanctions effective in creating autocratic breakdown, it's mostly saying no. That most of the time they're not going to lead to revolution. In fact, revolutions are really, really rare anyways, and it's not going to lead to a coup. But the literature on whether or not it can impact a conflict is saying something different, that sometimes, not all the time, but sometimes it can work. So if we think about the logic of why are we applying sanctions? Well, they're hoping that by strangling Russia's economy, that's going to lead to more pressure and more instability, and that's going to lead Russia to change course. And in this type of dictatorship that's very, very personalized, usually that can work if they are dependent on foreign aid. But we've got a lot of complications with this case because Putin, who's making all the decisions basically, and he's coup-proofed his regime because since 2012 he started to deprofessionalize the military, and that's why it's not been that effective. They've ousted all the key experts in the upper echelons of the military, but he has a lot of natural resources, and because he can rely on these natural resources, that's sort of like a lifeline. He also has China, and China is likely to, even if it says that it's not supporting Russia, it's likely to secretly militarily support it. And as such, this is that lifeline that keeps the conflict going. But there's going to be a lot that Russia is going to have to face. They have the currency is falling apart because of the asset freezes on its banks. You have more and more inflation. You have more and more people that are going to be facing food shortages. I mean, the sanctions haven't even really started to bite yet. But eventually, this is going to make it more complicated for Putin to wage war. I think it's really unlikely that his inner circle is going to stage a coup. They either share his worldview or are completely afraid of him, or they're sycophantic. There's more concerns about what's going on with the intelligence agencies. Possible that they'll be upset, but I think that's also unlikely. The military, as I mentioned, is already coup-proof, so I don't think there's going to be anything happening there. But I think would be more an issue for him is dealing with military defections. The morale of the military is very low, and the sanctions are going to take a toll on that. If you look at just even what they're being paid, you've got conscripts that are paid £25 a month. Contract players are, they're paid a little bit more. They are paid about £1,000 a month. All this stuff is going to, strain the military. All of the economic war tools used are going to strain the military in some ways. But that takes time to have an effect. And so I'm not clear if the sanctions have enough bite at the moment to stall things and to make an impact. But if we were to look at the literature on everything, sanctions don't have a very good track record on democracy, don't have a very good track record on human rights, a little bit better on conflict resolution, and sanctions work best when the objective is very limited and very specific, and when that country is really dependent on the sender of the sanctions. So that's my quick intervention, and I leave it to you if there's any questions, or I'm happy to actually listen, because it was very interesting hearing what others were saying from the legal standpoint.
So, Natasha, can I just put you on the spot before we go back to Q&A for one more point? Do you have a view with regard to, some people are saying that maybe the only way out of this is for within Russia, for a change there, and the change being forced upon Putin, and maybe a change of leadership there? Do you have a view as to whether that is a realistic possibility?
I think it's not realistic. I wish it was. I mean, possibly from intelligence forces, which apparently is the most powerful in the Russian regime, that that they could decide that this is just not going well, and the only way we can get rid of him is or change course in the conflict is to get rid of him. There was a former foreign minister of Russia that had said that they're more likely to stage a coup than to give Putin correct information. And as the war carries on and is not going well, it could be that there is more and more elites that find that they can't continue with this. And his age will, play a role if this goes on for a really, really long time. Let's say this is super protracted and so forth. But I think what is more likely is that the impact of the sanctions is that it will lead to a negotiation, and one that may have Russia de facto or even legally controlling part of Ukraine.
Okay, great. Thank you very much for that, Natasha. So we'll go back to the Q&A now, and there've been lots of questions coming in. I'll start with one that links to something that just came up previously in comments that Carla and I think Jeff may have made as well. And this is from our colleague Erin Pobji, and Erin's asking about the problem of immunities and whether that could be overcome using the jus ad bellum or IHL, in the sense that could one of these frameworks, perhaps under self-defense or somehow under IHL, provide a basis for displacing the immunity of Putin before foreign domestic courts. My own thoughts on that, Erin, is I don't see it. Self-defense, and you know this as well as any of us, self-defense is generally seen as an exception to the prohibition on force, right? So if that's the case, then I'm not quite sure how removal of immunities fits within that, right? Self-defense allows you to use force in a way that doesn't violate the Charter, but I think it's a stretch to put a removal of immunities into the type of act that would be justified under self-defense. And I think it's the same for IHL. I mean, if IHL allowed for removal of immunities just on the basis of needing to prosecute war criminals and so on, then that would have been the case in previous situations. I mean, it would mean that generally there's no immunities ever for war crimes. I'm not sure how this would happen. I think we need to be careful not to stretch the existing laws and frameworks to make them fit a specific case. You know, tough cases make a bad law. You know, in that sense. I would say that at least some of those that are talking, for example, now about some kind of special tribunal being put together, you know, when asked about the problem of immunities, the answer, I was at an event recently that perhaps some people here were at Chatham House dealing with this. And I think it was Philippe Sands who was saying there, where there's a will, there's a way. You know, and that's been practice until now. So if the international community decides it does want to set up some kind of tribunal, they will find a way around the problem of immunities. But you know, is that an answer? That doesn't tell us how. Clearly, it's a big obstacle. But personally, I don't see the self-defense or IHL routes. But perhaps Carla or Jeff, if you have other thoughts on this.
I would tend to agree with you, Noam, on that. I think if one looks at the jurisprudence on immunities and the range of different arguments that have been put forward about why there should be an exception to immunities in certain circumstances because of the need for access to court or because it involves a serious violation of human rights, essentially the courts have by and large rejected those types of, well, we need to get rid of immunities because there's something more important which trumps. The basic rationale being that immunities exist, they're not contingent. They are things which exist or they don't exist. So I think from that perspective, the idea that immunities could be lifted as some kind of defense would, I think, not be accepted if it was ever put to a court. But the question is, where would these things be decided? And there we go back to where there's a will, there's a way in terms of how and where these issues are decided. They're not always decided in courts.
Thanks. Did anyone else want to add anything to that? No? All right. Jeff, there was a question about how displacement might impact a reparation order in terms of implementation, if there is, and where do emergency plans fall, states permitting refugees to stay for certain periods and so on, and sort of temporary plans for refugees, where does that fall within the international refugee law scheme of things?
So let's talk about international refugee law, which is really very limited. Okay, international refugee law basically says to states, don't send people back to where they'll face armed conflict or persecution, non-reformer. Beyond that, it says very little. So there's no reference in the 51 Convention to the source state, for instance. So when you have people fleeing due to persecution, there's very little on reparation. Though if you if you take a look at paragraph 4 of the preamble to the 51 Convention, it does talk about international cooperation. You've got the principle of cooperation set out in Article 1, subparagraph 3 of the UN Charter. And since 2018, we've had the Global Compact on Refugees, which sets out in paragraph 4, this is not legally binding. Okay. So they're the sort of frameworks where you can start thinking about reparations and displacement. But alongside that, we now have the recent decision in the ICJ that Carl has already mentioned about between the DRC and Uganda, which did talk about reparation for displaced populations, said there wasn't enough evidence to talk about displacement in and of itself, but did recognize that this was a factor to be taken into account. To my mind, if you're going to have a proper reparations policy, you've got to put in place mechanisms that allow those who have been displaced to feel that they can return to their country of nationality and establish themselves in a safe and durable fashion that's sustainable. And reparations programs, therefore, have to take into account that lots of people have been displaced and they're going to come back, and they're possibly going to come back to nothing. Okay. Now, Carla will have had experience of this in the Bosnia, when she was working in Bosnia, about how displacement and property being taken over, people not being able to go back to where they had grown up, simply because that part of the country was now under the control of another side. This could be the problem if someone is Ukrainian, but they used to live in the eastern part, in the Donbass region. Are they going to want to go back there, even if there is peace? Okay, so these are issues which a reparations policy has to take into account. Not just what do you need to rebuild the state, but what do you need to rebuild a state that is now fundamentally different from the state that people left? Okay, because it's unlikely, looking at the situation as we now see it, that Ukraine will ever be the same as it was prior to this invasion. Okay, it's not going to be the same country. There are going to be changes made, either through the individual not wanting to go back to a particular part. Who wants to go back to somewhere where they faced, or where they could walk around the corner of the street and bump into the person who tortured them, who made them feel as though their lives were at risk and forced them out? Unless we have a prosecution system that prosecutes those people, and I'm not holding my breath, okay, you're going to have relocation within Ukraine post any peace settlement that's going to require a reparations program that takes refugees into account. What's really important, and this happens all the time, is that refugees are ignored during a reparations process altogether, and they're not taken into account because they're in other countries. Should they be allowed to take part in peace processes? Should they have the vote in any referendum about what's going to happen in the future? How do you allow out-of-country voting? All of these issues need to be factored in. It's possible, but it's quite often forgotten, particularly because the parts of the UN that deal with this are spread across New York, Geneva, and they don't necessarily talk to each other as much as they should. That's a different discussion.
Thanks, Jeff. Does anyone else want to come in on this? Okay. In that case, there was a question from a couple of questions from Michael Freeman, and they both go to IHL and the utility of it. And I actually want to, although I can answer from the legal side, I actually want to turn to Annie, if I may, just to ask, in your work with Civic, To what extent does international humanitarian law play a part or an important part in the policy discussions and in actually managing to achieve change on the ground?
Yeah, thank you for the question. I mean, certainly all of, the foundation of protection of civilians work as a concept does come from international humanitarian law. And of course, coming from the US perspective, we also deal with international human rights law when thinking about, US drone strikes outside of armed conflict. But yes, I mean, international humanitarian law underpins all the work that we do and is the foundation of all of our advocacy with states. That said, we also do, as you noted, a lot of policy work around both how do you actually operationalize IHL, because I think it's really important to be clear with states that it is not enough to just check the box and say, we agree with this, we have signed on to this, this is what we do, which I will say we see a lot of from the US, and actually say, no, you need concrete policies and practices and procedures that actually operationalize those commitments. And then, of course, there are these policy questions, right, about even if it is legal, should you do this thing? And oftentimes the answer is no, because of the harm that it would cause to civilians. So I'm happy to get more specific about that. Again, I'm a little bit out of my depth with more of the Russia-Ukraine, unfortunately, and I wish I could have brought some of my colleagues with me to talk to you all today. But yeah, it's a mix of both for sure.
Thanks, Annie. And just to add to that, because in the question, in the Q&A from at least the way it was phrased, Michael's question was asking whether IHL can act as a deterrent. And I think I'd say about that sort of when we talk about it being a deterrent, it kind of then includes an assumption that without this body of law, we sort of have a Wild West in terms of how states behave. And I'm not sure that that's the case, because humanitarian law itself rests on, and at least its basic principles rest on long historical, cultural, religious, social values that in some sense are inherent to the way warring parties behave. Even without it having, and before it was codified in this way. Now, detail has been added over the years, but I don't think it's necessarily in that sense sort of a foreign imposition on the way parties behave in a conflict. Also, I'd say perhaps more important than deterring, the role of this body of law in the context of conflict is putting the structures and patterns in place in advance. Right? So it's whether through domestic systems, domestic legal systems, but the practice of militaries, the training of militaries, military rules, rules of engagement, all of these, if they're formulated on the basis of international humanitarian law, then without the question of sort of deterrence and so on, they already affect the behavior of parties to a conflict during an armed conflict. But yes, as well, deterrence can play a part through prosecution of war crimes, the same way criminal prosecutions play a deterrence role in domestic systems. I think humanitarian law gets a bad reputation because of the focus that we see all the time on the things that go wrong, on the war crimes, on the violations. The reality, I'd say, is that most parties to armed conflicts abide by most of the rules most of the time. Now, those violations, be it, even if it's 20%, that's huge, right? That's death, destruction, millions of refugees and harm, but it doesn't mean that adherence isn't the norm, right? And it's the same in domestic law. Illegal acts occur every day, but that doesn't mean that the value of the law isn't there. There was another question, just if we're answering IHL questions from Michael, then there was just one other question there in the textbook, whether or what IHL says about targets that are used by both military and civilians, or civilian targets servicing the military. And in this context, I suppose the answer here, and sort of the straightforward legal answer, is this idea of sort of dual use objects and targets is actually not a legal concept. So dual use is a factual description. But as far as the law is concerned, there's a definition of military objectives, and something either meets that definition or doesn't. And even if it also services the civilian, or is used by both civilian and military, if it meets the definition of a military objective, which requires it to be, it depends on how it's used or for what purpose, nature, location, purpose, use. I won't get into the whole definition, but if it's effectively contributing to the military action of the other side, and by attacking it, you gain an advantage, a military advantage, then it could be a military objective. Now, if it's also used by civilians, you have to take into account the proportionality rule. So if the harm that will be caused to civilians or civilian objects is excessive in relation to the concrete and direct military advantage you're going to get from attacking it, then you can't attack it, even if it is a military objective. So that's sort of the rule that applies here. There were questions. I'll direct these to Carla. Two questions, one from Victor, one from Lorena. I'll put them together. And they were asking about the viability of potentially some kind of a hybrid tribunal. That some people have argued for this, looking at the Cambodia extraordinary chambers as an example, and what's the chances of something like this being created? Could that maybe solve some of the problems? Certainly we've seen some arguments being made that could be the best way to get around questions of jurisdiction and potentially even immunities, if it's done sort of with Ukraine and other states. So your thoughts on that? And likewise a question from Victor about whether we might see a claims commission such as we saw in Ethiopia, Eritrea. Is that likely or not? So I'll start that with Carla, but then if anyone else wants to jump in. Carla.
Sorry, I'm here. Thank you. Excellent questions from my two excellent students. On the viability of a tribunal, specifically for the crime of aggression, because of the particular problems with prosecuting aggression before the International Criminal Court, I think a hybrid tribunal is really the answer for that. A hybrid tribunal, just because it's Ukraine, I think it's problematic in the sense that one needs to be really careful about it, what it says about all the cases going forward before the ICC, and then all of a sudden a special approach for a country that many countries want to see justice for, whereas they're more lukewarm about other countries. So selectivity, I think, is a major problem. But for the crime of aggression, because there's no other opportunity, I would say absolutely yes. Will it get over the immunity hump? I'm not convinced, but maybe I'm a little bit more optimistic than Natasha in terms of how things might pan out in Russia in the short to midterm. But let's see what happens there. In terms of the possibility of a claims commission, I think that will depend on a number of factors. It will depend on how successful the asset freezing, seizing goes. It will also depend to an extent on whether any kind of a agreement can be come to in that respect in terms of liability. How would it be dealt with? But I think in principle, yes, if there is a clear framework for assets, then the possibility of a claims commission, it's there. It's something which has been used, let's say, only periodically. If I think about the UN Claims Commission, which was set up after the invasion of Kuwait by Iraq, that was fueled to an extent by the sale of oil. And then you have the Iran-US Claims Tribunal, which was funded in part by seized assets. So I think it's a possibility, but more often than not, it's not used. And one also needs to be careful about who has the ability to claim. Usually it will be a state-to-state process. The ability of individuals to access claims, it can be quite restricted, and that may impact on the results of such a process.
Does anyone else want to come in on this? Jeff? No? All right, thanks, Carla. There was a question from Andrew Fagan, and I'll direct this first to Jeff, whether the seemingly generous response of populations generally to the plight of Ukrainian refugees in the UK and in other places maybe could undermine the more hostile environment created by some governments with regard to refugees, and sort of is there a chance of basically governments becoming a little better because their populations seem to be more welcoming?
I see a flock of pigs flying through my window. Pardon my cynicism. I would love to believe it, but there's 82.4 million at the end of December 2020 displaced persons around the world. Oh, sorry, persons of concern to UNHCR around the world. 86% are in low or middle income countries. Since 2018, we've had the Global Compact, which was affirmed by the General Assembly, and that calls on states or the international community as a whole to provide fairer and more predictable burden and responsibility sharing. Now, we have had COVID since, and that did affect the implementation of the Global Compact, but I don't see it. I think it's a bit like going back to the 1990s, and we saw the war in the former Yugoslavia taking place in our living rooms on our TV screens, because Yugoslavia was close. And there was the capacity for the CNN, BBC, all of the big players to get out there and to show what was going on as it was happening real time. And I think that did change attitudes. I don't see that it had that large an effect on our willingness to take in refugees. We've all seen the filming that's come out of Syria, and our willingness to accept Syrians and Afghans hasn't really improved. Are we being more generous to Ukraine? Yes, we are being more generous to Ukraine. Will that have a long-term effect? I'm not optimistic, but I wish it would. And I think one of the things that should happen, and this goes back to the policy experts rather than the legal experts need to start referring to the documents I've been referring to much more to remind governments of their commitments. But the policy experts also need to be saying, by the way, what about the Global Compact? What about the Grand Plan? All these ideas that have been around for now sort of 5 to 10 years, we need to start using them more. When the guiding principles on internal displacement first came out in 1998, some would claim they weren't even soft law. Okay. Now we think of them as reflecting, at least in part, customary international law. If we start using these documents on a day-to-day basis with governments, maybe in 20 years' time, we'll be able to use them much more effectively when future crises arise. But no, in the short term, yes, it's wonderful. In the long term, not optimistic.
Hey, thanks, Jeff. There's a question for Natasha, whether the high number of sanctions, this question from Felipe, might cause an inverse reaction. Could it lead Russia to engage even more because they've essentially got less to lose and sort of back to the wall type of situation?
I'm not really sure, but that it's a possibility. I mean, if you apply it to authoritarian regimes, there's been a majority of cases where authoritarian regimes face sanctions and they become more repressive against their own people, and they engage in rally around the flag, techniques, and they're able to actually decrease the chances for democracy by using the limited amount of resources they have to pay off their own supporters. That comes to the expense of people that could challenge them. Now, in terms of whether it's going to make them more aggressive in the conflict, I mean, it's possible. Sanctions using conflict resolution, as I said, are a little bit more effective than in using democracy promotion and human rights. And we've seen that actually as the war strategy changed quite significantly. Putin became much more aggressive, going after civilians. It almost feels like it's like a scorched earth policy of just, maybe out of desperation because things aren't going well. But I think that's what's driving it rather than the sanctions. That the driving factor is the war is not going well. It's not going as expected. He thought he was going to quickly take Kyiv and take over the country and it would capitulate. And that's not what happened. And he had horrible intelligence. We know he had horrible intelligence because he purged those that would give him good intelligence. And I think that's what's driving the aggressive behavior more so than the sanctions. But I'm not familiar with cases of sanctions being applied on conflicts and leading to more aggression, just in the research that I've looked at.
Okay, thanks, Natasha. Carla, you want to come in on this?
Just maybe this is just a reflection and perhaps another question for Natasha on the sanctions. It brings, I wonder whether there's a worry of how good states are going to comply with the sanctions, in the sense that there's so much money involved, the relationships are so entrenched, so many states have so many interests at stake. Are they going to keep to it? And if they don't, what are the risks and what are the messages that plays? And in the back of my mind, I'm thinking about Libya, all the sanctions in Libya, yet all the players who are routinely ignoring those sanctions to the point where the sanctions become almost meaningless.
That's actually one of the biggest critiques of sanctions. They're often really leaky. They're not complied to, or they're not comprehensive enough, and there's different ways out of them. I mean, we can look at the South African case that they never applied sanctions on gold, on diamond, and coal. And South Africa was a leading exporter of coal to Europe, even in the midst of apartheid. With the case of Iran, you have another issue that the sanctions are applied, but the Revolutionary Guards earn most of their money through black market activity. So they have ways of going around it. And I think there's going to be other issues of these sanctions being leaky as well, where they're either going to go around it, there are other ways of amassing wealth, or they won't be applied to where it really hurts. And so, I mean, these arguments are why sanctions are not considered a legitimate enough tool, but they're still what policymakers think is the main tool at their disposal because they don't want to engage in direct conflict. But all these factors, I think, played into Putin's thinking, that it would be difficult for the West to really go where it hurts. And we know that even how we made a big deal about all these banks being banned from SWIFT. Gazprom has not been banned from SWIFT. And of course, that's associated with its oil industry and gas industry, natural resource. So there's these loopholes either on compliance or, because we just aren't even targeting an industry that makes it very difficult.
Thank you. So there have been quite a few questions on IHL, on laws of armed conflict. I'll try and address a couple of them together quickly. So there was a question from Robert that came in very early on, just as we were starting already, and that is whether President Zelensky acted himself unlawfully by directing Ukrainian citizens to essentially to bear arms against the Russian aggression, given that these people are not members of the armed forces, and getting civilians involved in the fighting. And this is another one of those areas of IHL rules that has become a little bit more complicated looking at this conflict, and it's also raised the possibility of returning to a concept that hasn't been seen for a long time, and that's of the levy en masse, which exists in the Third Geneva Convention Third, Fourth, and talks about the basically it's the question of when the civilians of a state rise spontaneously to push back an aggressor, and whether when they take up arms in that context, would they be entitled to prisoner of war status, right? And many have said, well, that sort of a historical concept doesn't really happen much, but this is an example where it certainly may have applied in that sense. And what it allows for is the idea of civilians participating in the fighting without uniform, without being under any centralized command, although they are still expected to carry arms openly, and then being entitled to prisoner of war status. But this only applies in the very early stages of a conflict. It's those first moments of a spontaneous trying to stop. It's a question of how long it continues to apply for once the government is organizing. And in this context, as we've seen, it's been said in Ukraine that there has been some organization from the government side of sort of getting civilians to become involved, even handing out weapons, and so on. Now, this doesn't necessarily have to be unlawful, right? Because you can have volunteer groups. You can have different forces that operate under the command of the state and on behalf of the state. And IHL recognizes such groups. So it is certainly possible that civilians that are taking part, if they're now doing it in a more coordinated manner, would be operating on behalf of the state. It certainly seems from some of the reports that there is some kind of command structure going on there, some kind of organization, and even an attempt to distinguish themselves from the other civilians by, I've been reading about yellow armbands being used by some of these groups. Now, what's actually the relevance of all of this? From an IHL perspective, it could entitle them all to prisoner of war status if captured. Of course, that's assuming that Russia would properly apply the rules of entitlement to prisoner of war status to its detainees. And for those that don't sort of work in this field, what that means by having, in this context, prisoner of war status means that they wouldn't be able to be put on trial for lawful acts of war. And they have to be repatriated at the end, released and repatriated at the end of the conflict. But also, it also means that these people are legitimate targets during the conflict. And that's true, by the way, also if they aren't formally incorporated, and even if it's civilians that are sort of more randomly taking part in hostilities, if they're picking up a gun and they're fighting, then at least for the time that they're doing that, they could lose their civilian protection. And that's something that needs to be taken into account as well. Another IHL question from Francesco was whether it would be lawful for Russia to target military aid directed to Ukraine before it even reaches Ukraine. And this is a complicated and interesting question. So there's the IHL side of it, and there's the jus ad bellum side of it. So under IHL, direct military aid, a shipment of missiles and whatever, certainly is a legitimate target, right? There's no question that you can attack military, supplies, ammunition that's coming into your enemy during an armed conflict. The question then is, can you do that when it's in the territory of a party, of another state that's not a party to the conflict? And that comes into the jus ad bellum, right? What's your justification for using force on the territory of another state? And here you'd need to justify this under the rules of the jus ad bellum, and it's not impossible to justify in that sense, to be perfectly honest. I mean, there's a lot of debate around this, but notably this has been happening quite a bit in the Middle East, with Israel attacking various shipments of things that are meant to be going to Hezbollah. And carrying out attacks in Syria and further beyond, and attacking shipments of weapons and so on, and sometimes also further south of Israel in other countries, and using this same logic that in theory Russia would use if it wanted to strike supplies of military aid to Ukraine. So this is a complicated issue. It raises questions also of whether other countries become party to the conflict themselves. At what point when they're assisting Ukraine, do they become a party to the conflict? So certainly, when people talk about a no-fly zone, if they would implement that, and if they would start shooting down Russian planes, they would be a party to the conflict. Where it's, sort of probably below that threshold, things going on right now, such as intelligence sharing, for example, if it's not sort of real-time intel to support a particular strike, that probably doesn't make them party to the conflict. Providing arms on its own is probably not enough, also from an IHL perspective, to make them party to a conflict. But there's a lot of debate around this, and it's interesting if you follow the news within the US, and Annie's probably, I don't know if you're going to want to say anything about this from the US perspective, but I've seen a lot of reports in the US where they're saying that the lawyers are preventing further involvement, right? When the government's being asked, why aren't you doing more? Why aren't you supporting Ukraine more? And they're saying, oh, the lawyers tell us we can't. Right now, that's a bit ridiculous, right? It's not the lawyers that are saying you can't. It may be the case under US domestic law that certain actions can't be taken legally without particular types of authorization. As far as international law is concerned, again, it's not that the US can't. They could get involved. They could get involved or, to the extent also of taking part in the conflict under collective self-defense at the request of Ukraine. It's a choice. The issue is the lawyers might be saying, if you do X, Y, or Z, you will become a party to the conflict. And the politicians don't want to be a party to the conflict for other reasons. But it's not that the law is preventing it. The law is just clarifying what the implications would be. And Annie, I don't know if that's been coming up in any of Civic's work. Maybe if you have some thoughts on that.
Yeah, I mean, so again, I won't speak as much in this case to the Ukraine context, but certainly we have seen that concern in, U.S. arms sales to Saudi Arabia, for example, given Saudi Arabia's conduct in Yemen. And there we've actually seen examples of, as you mentioned, while they may not be a party to the conflict under that dynamic, we have actually seen concerns from the State Department. There was like a State Department memo that I think was leaked or at least described a few years ago around lawyers actually being really concerned about the possible complicity of the U.S. in, aiding and abetting war crimes, essentially, and concerns around that. So certainly in that regard, there's that concern when it comes to security assistance. And then, yes, as you mentioned, obviously U.S. domestic law would play, I hope, an important role in a decision to actually become a party to a conflict, given the war powers role of the U.S. Congress.
Thanks, Annie. Carla and Jeff, there was a question about Ukraine, or at least it's been reported, having banned men, or at least men of a certain age, from leaving the country. It's unclear to what extent this is actually happening and being enforced, but do you have any thoughts on this in light of everything from the ICCPR and freedoms of movement and right to leave, asylum and refugee law jurisprudence, conscientious objection, and so on?
Yes, it was Marina Sharp who sent in the question. Thank you, Marina. It's a complicated one, is the easiest answer to this. So on right to leave, you have got in article, and trust me, never try and remember law, always try and read it. It's much easier. If you turn to Article 12.3 of the ICCPR, which is about right to leave, the above mentioned right shall not be subject to any restrictions except those which are provided by law necessary to protect national security, public order, public health or morals, or the rights of freedoms or others, and are consistent with other rights in the covenant. So I can see an argument under Article 12 that you actually could impose a restriction on men who are deemed to be of fighting age from leaving the country in order to protect the country. We allow conscription, okay? There is no sort of law against conscription. That's not what's happening here, but you can see the analogy. And of course, anybody else has the right to volunteer, as we've seen, to fight in Ukraine. When we come to refugee status, the right to leave your country is part of being able to seek asylum, the right to seek asylum. I don't quite see how this one would play out, so I can't give an answer. What I would say, though, is that as regards somebody who is trying to leave the country because of conscientious objection, for instance, and who is prevented, that would, to my mind, be possibly a form of persecution that if they were to leave, okay, they could use as the basis for a claim to refugee status if they got to another country. So then I'd have to know Ukrainian law on conscientious objection, and unfortunately that one has skipped my previous studies, and it's not in any of the books that I've currently got sitting beside me to be able to look up. But it's a lovely question to which there is no simple answer, which is why it might just suddenly appear in an exam paper I'm setting one day.
Carla, do you have any thoughts on this? No. So, all right, there's quite a few more questions still coming in, and we're not going to be able to get to all of them. There've been a couple of questions about the role of corporations and potentially mercenaries as well in this conflict. I won't open that up unless anyone specifically wants to respond to that, but just to say that there is another event that unfortunately overlapped a little bit with this one of colleagues with the Essex Business and Human Rights projects that's happening right now, but I believe it is being recorded, and they are looking specifically at private actors and businesses and their role in this conflict and everything around that. So I would suggest looking up the recording. I assume sort of within a day or two, it'll be up online. And I'm expecting that there'll be a lot of discussion of that there.
If I can,
Annie,
all I will do is make a similar pitch, which is that I'm actually also happy to report that Civic has a report coming out also very soon on private military contractors and mercenaries and the impact on civilian harm. So please stay tuned for that as well.
Great, thank you for that. There's another question from Erin Pobji saying that Russia's invasion of Ukraine has been compared to previous acts of aggression, especially the US invasion of Iraq, to either critique or justify the international response to the current crisis. Are there any differences between these two acts of aggression that you see as significant and that may justify the different nature of the international response? Or are such comparisons simply fundamentally problematic and dangerous? Thank you, Erin, for asking a dangerous question that can maybe be a bit more complicated to answer politically. I'm sure that a few people might want to comment on that. From my perspective, I think, and I said this at the beginning of this session, I think we need to be careful not to distinguish between, from the perspective of civilians, the harm and devastation of conflicts on the civilian side is the same in a sense everywhere. You don't compare it's worse here, it's worse there, and whether it started off as being lawful or unlawful or debatable doesn't really matter to the civilians who end up with death and destruction and long-term harm to their society. In terms of the legal arguments around it, so to my mind, there is a difference, and I'm not saying that to say that that this is worse or one is more unlawful than the other, because the invasion of Iraq was unlawful. I don't think there's any dispute. But I think in that case there was a whole legal sort of debate and discussion around it. There were attempts to go through the Security Council to try and justify it initially. There were attempts to link it to self-defense. There were attempts to try and place this within the frameworks of international attempts that were misguided and sometimes manipulative of the law, and at the end, proved to be, and it was unlawful. So that's not to say that anything there was okay, but there's something about this particular conflict that looks more like a sort of an old-fashioned sort of 18th, 19th century, I want your country and I'm going to come in and take it. Right, without trying to sort of disguise it and under the guise of, we need regime change for the good of the people. We have Security Council authorization. We have, there isn't an attempt to place it within the existing framework. And it seems in that sense, at least from the perception, it seems like more of a threat to the international order. But like I say, that doesn't mean that sort of it's not more unlawful or less unlawful. Both are unlawful. But I think in the terms of the way it's perceived, some of the response that we're seeing, I think that might be the reason that it seems sort of more threatening to the international legal order. Carla, please.
Thank you. I think that takes us down a perhaps dangerous route of looking at one kind of response, which is perhaps more polite, and another which is more brazen, and pitching them somewhat differently on the basis of that politeness or lack of politeness. And I would worry about that. I don't see that there's a major distinction. I know you haven't said that there necessarily is, or that it should necessarily have a different kind of result. But I would worry about really trying to overly distinguish, because at the end of the day, in terms of what happened, you had an invasion. The invasion was not lawful in either case, and then you have a consequence. I think those fundamentals are worth. It's more important perhaps to underscore the similarities than the differences in this case.
Yeah, and I don't think I disagree with you, Carl. I think my point was more about why are we seeing, at least politically, a different type of response, and I think what I was saying was I think in terms of the response that we're seeing, certainly in terms of how states are reacting, my point was why maybe they're reacting that way, not that it's correct to react that way. But
I see that you haven't been it's not that you've justified. It's just more how one frames it.
Yeah, and that's what I'm saying. I think it's being framed in that way, and therefore we're seeing this type of response. But as I said, an unlawful invasion is an unlawful invasion, and all unlawful invasions need to be responded in a similar, responded to it in a similar manner. But circumstances of each case can affect how we see, what type of political responses we see and how people perceive this. Natasha?
I was just thinking, I mean, I'm not saying this is right or wrong. I'm just saying that, if you think about the way Zelensky has been very compelling in speaking directly to Congress or to Parliament and talking about, Ukraine as a democratic nation that has been attacked. I don't know if we've had the same response if Russia, let's say, attacked Belarus. He's been really clear about that the Ukrainian nation it's an independent sovereign nation. They just want to be free to, have their own, to be in charge of their own affairs, and that they are trying to move towards democracy and ridding themselves of corruption. So I don't know if he's played a role in, because I think he's been quite effective actually in getting a lot of support and getting such comprehensive sanctions applied to Russia.
Yeah, that goes back again to sort of its perception, right? So invading a democracy and invading an authoritarian regime are both equally unlawful as far as international law is concerned, but the reaction that you might see in other states might be different, but that's separate to the question of whether they're equally unlawful. Does anyone else want to come in on this or on any other final points before we conclude? We're coming to the end of time. If not, okay, in that case, we've had, I think, some excellent presentations, but more than the presentation, I mean, I enjoyed the presentations, but the discussion, the Q&A was fantastic, and that's thanks to the participants here just as much as it is to our amazing panelists. So thank you to the panelists, thank you to the participants. I think, to end this, maybe it's my takeaway from some of the discussion here is that ultimately the reaction from across all international bodies and legal institutions, I think, does demonstrate that international law is alive and kicking. And it's not just the UN bodies, also ICJ, potential future tribunals, but also the legal mechanisms through which sanctions that we spoke about, Natasha spoke about, are being enacted. That's also part of law and legal response to conflicts. And some of this will take time, especially actions that require investigations and detailed fact-finding. And it's true, legal responses don't resolve a military crisis. Only diplomacy and other actions by states can do that. But the international legal world has responded as robustly as it ever has. And I think the effects are and will continue to be felt for a long time. And in the meantime, we can only hope that this war comes to a swift conclusion in which civilians receive the protections that they deserve, and that everyone affected receives support in Ukraine and in any place to which they may have fled. So thank you again to our panelists. Thank you again to our participants. And I hope the rest of your day goes well. Thank you and bye-bye.